Well, good afternoon. I'm very glad to see you all here. I'm Larry Tribe, and I'm honored that Carol asked me to moderate this closing panel discussion of the conference marking the publication of Carol and Jordy's monumental work, Courting Death. Unfortunately, the only parts of today's conference that I was able to attend were this morning's panel, which was spectacular, I thought, and this final panel, which I hope will not disappoint. If the panel on race and the panel on broader criminal justice issues were nearly as exciting as I found the first panel, and if Don Verrilli was his usual very thoughtful and deeply insightful self, then I must have missed some pretty awesome presentations and discussions. Important as all of us regard the ultimate abolition of capital punishment in the United States to be, at least as important, I think, are the lessons about what Carol and Jordy describe in their book as issues of political backlash and legitimation, discourse shaping, and institutional and remedial constraints, all of which I suspect will feature in this closing panel's presentations. Unavoidably hovering over the whole conference, certainly over this morning's panel, has been the shock delivered by the American electorate 10 days ago. Shock that most of us...
By the Electoral College.
Well, he's not president-elect yet. That's December 19th, but we're shocked anyway. And we're still processing it. And in that connection, I was struck by a remark that Carol made this morning, responding to a question about how relatively little progress the Obama administration seems to have made over the past 8 years with respect to the death penalty and criminal justice reform generally. Carol said that one good thing about that otherwise lamentable omission is that it prevents criminal justice reform from becoming an Obama legacy item that those who rose to power on November 8th will feel a need to repudiate. That was part of Carol's search for silver linings. It's a search that I've been engaged in too, 24/7, ever since the events. I suppose another of the very few silver linings we can fasten on is the teachable moment silver lining. It involves the lessons that we are having to learn anew about things like the huge role played by contingency, the difficulty of predicting, as Carol reminded us, I think, especially the future, as Yogi Berra famously observed, and the crooked path that we seem destined to follow toward the moral progress that Link Kaplan talked about and Michael Meltzner has sought, a point that Evan Mandery quoted from Courting Death this morning. Even if, as Martin Luther King Jr. believed, the long arc of the moral universe ultimately bends toward justice, we are clearly living through a bracing reminder that the arc of that universe sometimes reverses course and sometimes does backflips. I found especially clarifying this morning Corinna Lane's framing of Courting Death in terms of the way that the dense jungle of legal regulation of capital punishment over the past 4 decades has served mostly as a facade to the end of disowning death, enabling the perpetuation of a system that, as she brilliantly put it, kills without any killers, a system in which nobody has to take responsibility for the harms inflicted. I shared the sense that Jordy Steiker expressed when he generalized that observation to a theme central to the work of the great Robert Cover, that we use law and legalism to cover, as it were, to mask violence and injustice, even while telling ourselves that we use the rule of law to attain justice. I've concluded over more than 4 decades of thinking and teaching and writing about constitutional law that a surprising amount of that body of law is all about the passing of bucks and the evading of accountability. Well, I hope today's panel will offer some reflections on that broader theme and on the aspiration to make law more of a force for justice than a mask for injustice. And I hope there'll be some reflection on what the election and the upheaval that it portends means for that aspiration, including what we as scholars and students and lawyers might do to justify not losing heart altogether. Now, your materials contain bios of each of our very distinguished panelists, so I don't have to introduce them. As usual, I can say they need no introduction, although this time it's actually true. I think they'll talk for 15 to 18 or so minutes each, and then hopefully that will leave some time for interchange within the panel and with all of us. Our first panelist is Pam Carlin, the Kenneth and Harl Montgomery Professor of Public Interest Law and co-director of the Supreme Court Litigation Clinic at Stanford Law School. Pam?
Well, when the New York Yankees celebrated Yogi Berra Day, Yogi Berra got up and said he wanted to thank everybody for making the day necessary. And so I would like to thank Carol and Jordan for making today necessary, and also observe that there's another Yogi Berra quote that I think their book illustrates quite powerfully, and it's not the one about it's tough to make predictions, especially about the future, although I'll turn to that in a moment, but also a line that he once said that I think explains in a very succinct way a lot of the book's argument about why the death penalty is falling apart, which is a line Yogi Berra said about going to a restaurant. And somebody asked him, whether he was going to go to a particular restaurant. And he said, "No one goes there anymore. It's too crowded." And I think that's actually a pretty apt description of parts of the dynamic that Jordan and Carol talk about in their book. At a level that's perhaps subconscious, or knowing Carol so well, a bit poetic, there's something striking about the titles of two of Carol and Jordan's most perceptive works about capital punishment, the work we celebrate today, which is Courting Death, and a piece from a decade ago in the Journal of Criminal Law and Criminology, The Seduction of Innocence. Having read Seduction when it came out in 2005, one of the things I'd suggest is that Carol and Jordan's journey in their careers in some ways mirrors the jurisprudential journey that Courting chronicles, one in which unpredictable consequences show, and here we turn back to that famous Yogi Berra quote, that it's tough to make predictions, especially about the future. And I think when it comes to constitutional litigation more generally, part of the reason it's tough to make those predictions about the future is there's a short-term future and there's a long-term future. And the idea that the future is unidirectional and that it's not cyclical in some ways with ever-expanding cycles turns out, I think, to be a mistake. So, for example, there's a wonderful quotation from a president to whom we'll all look back nostalgically at his reason and the like, George W. Bush, who said, "I believe we're on an irreversible course towards more freedom and democracy, but that could change." And I think that is a lesson that we have been taught in several areas of constitutional law, perhaps none more than the right to vote, where I think we are now looking at an attempt at a second redemption that would end the second Reconstruction. In my comments today, I want to do two things. First, I want to take Chapter 7 of Courting Death, in which Carol and Jordan identify on page 218 what they call four of the most interesting and generalizable aspects of the court's regulation of capital punishment, and they match each of those aspects to another recent area of constitutional litigation, and I want to shuffle the pairs that they do. Then I want to return to the question of innocence and suggest that it offers a particularly pointed illustration of a critical feature of successful constitutional litigation campaigns, something Derek Bell once called the interest convergence hypothesis, but one might just as accurately call an appeal to solidarity or to empathy. Now, in Chapter 7 of their book, Carroll and Jordan identify 4 repercussions of the court's intervention in capital punishment. The first of these is political backlash. The second is legitimating efforts. The third is remedial constraints. And the fourth is discourse shaping. And they take each of these ideas. Political backlash, you pretty much all understand. We've talked about that several times already today. Legitimating efforts, people pretty much, we've talked about those quite a bit today. I'm sort of reminded standing up here now of a quotation from one of my other favorite quotable sources, Elaine Jones, who says, a lot of times everything's already been said, but not yet by everybody. The third, remedial constraints, is there's just a limit on what the courts can do in trying to remedy conditions, they say. And the fourth, discourse shaping, is about how what the court does changes how people generally talk about a problem. And what Carroll and Jordan do in Chapter 7 is they match these repercussions one-to-one to several of the other areas in which the court has significantly intervened in the same time period. So for backlash, they compare the backlash in capital punishment to abortion and the abortion litigation. For legitimating efforts, they compare the ways in which the court has legitimated the capital punishment system to the way that some of the things the court has done in police practices legitimate police practices. For remedial constraints, they talk about how there are constraints on the court's just ability to remedy the problems in capital punishment, and they compare that to some of the remedial constraints that have affected the Supreme Court in its voting rights work, most notably with respect to redistricting. And then with respect to discourse shaping, they compare the discourse as it got shaped in capital punishment with the move from moral arguments to arguments of cost-benefit analysis in various ways, to the way in which the marriage equality litigation shaped our discussion of equality. In each of these, one of the things that's, of course, quite striking is the centrality in some ways of race. And you'll see that as I trace out through these. But what I want to do now is shuffle the deck a bit. Now, there are actually 16 permutations here of repercussion and area of law. I don't really have the time to grind through all 16 permutations of repercussion and doctrinal area with you, although I did it as an exercise in preparing my remarks to figure out which ones would be best. So let me just pick a couple of them and talk about them. So consider, for example, backlash. Jordan and Carroll offer a sophisticated account of the extent to which backlash in the capital punishment area might be tied to the extent to which the court's decisions tap into a broader set of concerns. In the case of the death penalty, the identification of the NAACP Legal Defense Fund, not only with the abolitionist movement, but also with the civil rights movement. In the case of abortion, the links between the backlash to abortion generally and a sort of anxiety about changing sex roles and family roles. So a backlash towards women's issues more generally, even though, of course, as we all know, at the time the Supreme Court decided Roe, it decided it more as a case about autonomy and privacy, and indeed more a case about professional judgment by doctors than a case about women's equality on its face. Now, at one point, say right after the 2004 election, we might have seen a similar kind of discussion of gay rights and backlash to the U.S. Supreme Court's decision in Lawrence and the SJC's decision in Goodridge. What's interesting to speculate about today, particularly in light of the fact that in his Sunday interview, Donald Trump declared same-sex marriage, quote, settled, unquote, in the same interview where he pledged to appoint justices who will absolutely vote to overturn Roe against Wade, is why these two areas that each involve the regulation of sexuality have seemingly diverged so much. Now, one thing I've suggested elsewhere is that this may be in part a function of the fact that over the period between Thornburg against American College of Obstetricians and Gynecologists, sort of a high water mark of abortion rights at the Supreme Court, and Bowers against Hardwick, which was decided the same term and is really a kind of low water mark for respect for gay people at the Supreme Court, to now, one of the things that has changed most profoundly is that gay people have come out of the closet, while women who've terminated pregnancies have gone deeper back into the closet. And so the ability of the justices and the public generally to put a human face on the issue that's being discussed is very different now for those two groups. And in part, it may also be a function of a point Carol and Jordan make about the fact that abortion is much more subject, as is the death penalty, to micro-regulation on day-to-day repetitive ways than marriage is. That is, once you declare marriage a right, there is going to be some resistance, but it's much harder to have the kind of resistance there that you could see either to abortion or to restrictions on capital punishment. Or consider legitimation. Carol and Jordan point out that in the context of capital punishment, the court's interventions have created a legitimating and misleading impression that the problems that prompted its involvement in the first place have been tamed. They then show, with respect to their pair here, which is with regard to criminal procedure rules, how what Carol aptly denominated in her own work that Jordan contributed nothing except being a great brother to, inclusionary rules in civil. Look, I have a brother who's a lacrosse coach. He and I are never writing an article together. I guess it could be kind of like the biathlon, law and lacrosse. They both begin with LA, and other than that, they have nothing in common. But what Carol shows there is that what she calls the inclusionary rules, leave the public with the sense that there's actually constraints, while allowing all of the evidence that seemingly was being constrained to come back in. Let me just now talk about legitimation with regard to some of the race cases. And obviously a kind of starting point into this is the point that one of the things the Supreme Court is doing in its death penalty work, I would suggest, is by finding examples of extraordinary racism, the Buck case, or the Foster case, or the like, and striking down the death penalty there, the court builds up credibility that it is an institution that cares about race discrimination and that is committed to rooting out racism, that it can then draw on, because it's legitimated itself there, to dismantle other aspects of racial justice. For example, the same justices who are, I think it's no accident that the Chief Justice wrote Foster and then turns around and dissents in cases involving affirmative action. And most strikingly, in 2013, in the Supreme Court's decision in Shelby County against Holder, declares that we have solved the problem of minority disenfranchisement in states like Texas and North Carolina, so that the preclearance provisions of the Voting Rights Act are no longer a response to a contemporary problem. The thing that the Chief Justice's decision in Shelby County reminds me most of is some of you will remember an old Tom Lehrer song that has a line about, we taught the Germans a lesson in 1918 and they haven't bothered us since then. Because the minute that the Supreme Court took the tourniquet off, the wound spurted open again. And similarly, the Supreme Court in the voting area has shaped the discourse of voting around a cost-benefit analysis in which specters of fraud get weighed against actual evidence of exclusion. And of course, it turns out in both capital punishment and in voting rights that the major progress is often made not just because of Supreme Court pronouncements, but because the political branches create institutional structures that change the operation of the system on the ground. Earlier in the book, Jordan and Carol offer the example of how California's provision of a series of state-created protections and institutions and offices has effectively turned the death penalty in California into a symbolic penalty rather than an actual penalty. But so too with respect to voting. Real enfranchisement in the South came not from the decisions directly of the Supreme Court, but rather came from the fact that the Voting Rights Act sent federal examiners to register voters in the South, more of whom were registered in 2 years by federal examiners than had been registered due to all of the litigation that occurred from the passage of the 15th Amendment until 1965, and came from the Voting Rights Act's preclearance provision, which forbids states from making changes to the law, and finally came from Section 2 of the Voting Rights Act, which imposed a disparate impact standard that the Supreme Court has never been willing to impose as a matter of constitutional law. Finally, let's think about discourse shaping. Here's the one place where I think I have a bit of a quarrel with Carol and Jordan's account, and this difference will take us back to the innocence movement in a way. Carol and Jordan write on page 246 of the book that the overwhelming flavor of current public debates on capital punishment is relentlessly pragmatic, and on page 247, that almost no one today speaks primarily in the language of dignity of human beings that Justice Brennan used in his Furman opinion. I don't think that's actually completely true, and I think their earlier account of the innocence movement and the traction the innocence movement has had contradicts this, as does obviously the work of people like my colleague Larry Marshall and like. Now, to be sure, there is some common cause or some coalition here being made with the cost-benefit folks. But here, as with, I think, their discussion of marriage equality, I think Carol and Jordan may be underplaying a little bit the essential role that ideas of dignity and empathy play. As with the innocence movement, which they note on page 209, attaches names and faces to the death penalty's flaws, so too the marriage equality movement used the stories of people like Edie Windsor and April DeBoer and Jane Rouse and Jim Oberfell to personalize the claim of gay people to equal dignity and respect. One thing also that's different here, and I think this is a really striking difference, is the role of empiricism in the two areas. We heard a lot of discussion earlier this morning about the court's decision, and the book talks about this at some length, not to pay attention to any of the empirics on race discrimination and the death penalty in McCleskey against Kemp, that Justice Powell's opinion ultimately just says, okay, take it as a given, but let's just ignore it. That's in striking contrast to, I think, what happened with the marriage equality litigation, which was the most important moment, I think, in that entire litigation was the decision by Chief Judge Vaughn Walker in the Northern District of California to actually hold a trial rather than deciding as a matter of law whether California had any justification for its marriage statute. Because forced to come into court and actually bring in experts and the like, the case on the other side withered and left us with the case that Carol and Jordan talk about in the book, which is a kind of ridiculous sort of inverse 1.5 twist version in which the argument switched almost like that from an argument that gay people were not entitled to get married because they were uniquely immoral and marriage is a kind of reward for being in a moral relationship, to an argument which they don't completely tease out, but because they talk mostly about Dick Posner and not about the New York Court of Appeals version of the argument, an argument that the reason why gay people don't need to get married is they are uniquely moral as compared to straight men who are so reckless and feckless that if we didn't have marriage to tie them to their children, they couldn't be trusted. And you know, the moment at which you make an argument like that is the moment at which the argument is really over. So what's striking to me is the extent to which gay rights successes on the national stage have involved two of the most conservative institutions in American life. The filmmaker John Waters famously once said, "I always thought the privilege of being gay is that we don't have to get married or go into the army." But those are the two rights or obligations that have admitted gay people even as we continue to struggle in the fight over things like public accommodations and employment discrimination. Waters' point, which echoes something Carol and Jordan wrote about the innocence movement back in 2005, reflects a concern that litigating in areas that are especially likely to resonate with people outside of a movement may backfire by deflecting attention from deeper problems and by entrenching the status quo beyond this narrow area of agreement. But I think it's worth at least considering that this kind of litigation, by sparking some forms of empathy in which the majority puts itself into the shoes of at least some capital defendants and at least some gay people, is the only way to achieve enduring reform through constitutional litigation. Thank you very much.
Well, I'm the only person here who's entitled to have a double portion of pride in this book because I'm a colleague of both Jordan at the University of Texas Law School, where we have taught courses together before, and in the fall semesters when the Harvard Law School has been kind enough to have me as a member of faculty. I'm a very happy colleague of Carol as well. So I could not be prouder and happier about this absolutely splendid book. I also want to return for a moment to the person I described earlier today as the brooding omnipresence over many of these discussions, that is Tony Amsterdam. Because I mentioned that I went to Stanford in part because of Tony. I left, I'd been teaching political science and thought that I would do something useful with my life by becoming a cause lawyer. And Tony was obviously the instantiation of that. And certainly the key experience for me at Stanford, besides working with Paul Brest, was being Tony's research assistant during one summer on a cert petition on an integration case. He is certainly the one true legal genius I've ever worked closely with, a remarkable person in every way. He did not admit me to his criminal defense seminar because I think he recognized, perhaps better than I, that I didn't have the fortitude to be a cause lawyer. I did write one amicus brief in a death penalty case for William Boyd Tucker, which was unsuccessful. I taught professional responsibility, and the brief focused on professional responsibility problems of the prosecutor. It failed, and I certainly felt a twinge when I read in the New York Times that William Boyd Tucker had been executed, I think by the state of Georgia. I actually really can't imagine what Steve Bright, who was another hero of mine, must go through regularly, and what the people who really did take the criminal defense seminar and have tried to emulate Tony would go through. But that's not the only thing I want to bring up with Tony, because he made his reputation in the 1960s not only as a genius through his student note, the void for vagueness doctrine, Supreme Court, but also basically inventing or developing the removal doctrine. Get everything into federal court, because federal courts would be solicitous of reform sort of claims. I think it was 1978, it might have been 1979, it really doesn't matter. It was after he moved to NYU. He gave a talk in New York that was actually covered by the New York Times, in which he said, keep your cases out of federal court. Litigate on state constitutional grounds. Indeed, I had an academic fantasy experience where a case that began in the Princeton Traffic Court ended up in the U.S. Supreme Court. And I asked Tony to sponsor me for membership in the Supreme Court bar in 1980. He sent a very nice note saying he'd be glad to do so because it was the only motion he was confident that he could win before the U.S. Supreme Court. And this is 1980. And quite frankly, I'm not sure that things have gotten that much better. One might be able to cite certain victories like Obergefell, but it obviously took quite a while. And it also raises other broader issues. Because except for the amicus brief, I've had no contact really with death penalty litigation. There's no good reason for me to be part of this conference other than the kindness of Carol and Jordan inviting me. But one of my other mentors was Robert McCloskey. And I have tried to keep his book on the American Supreme Court alive. And McCloskey takes a more longue durée view of the U.S. Supreme Court. It was interesting that all the comparative cases that Pam mentioned are really very recent. They don't take note of the entire 225-year history or so of the Supreme Court. I am famous and notorious for not teaching Marbury versus Madison, which I regard as a waste of time, given other cases that one could teach if one takes the time that Marbury takes to teach well. And those cases for me include slavery cases, include in particular Prigg versus Pennsylvania. And it does seem to me very important to realize that the United States Supreme Court, for most of its history, has not been hospitable to anything that could be called progressive reform. And the slavery cases make this clearest. And one reason, very frankly, it is important to be aware of Prigg as well as Dred Scott, is that Prigg was written by Joseph Story, who is a hero of the Harvard Law School. And it develops the argument. He says there is no single theory of interpretation that justifies upholding the fugitive slave law and self-help repossession of slaves, which is another important holding of the case. But basically, it's part of the deal that was made in 1787, and it's necessary to save the Union. And it really captures very strongly a pragmatic emphasis that may even be correct. That it is, after all, if you think the Constitution of 1787 was worth it, with the two great compromises, first of the Senate and equal voting power in the Senate, which continues to plague us today, and then, of course, far more seriously as a moral wrong, the original sin of slavery, then why isn't it also worth it to recognize the implications of the deal in later decisions and try to maintain the Union? One can also look, of course, at the post-Reconstruction cases, which are nothing to write home about. And it's not only Plessy versus Ferguson, it's obviously the slaughterhouse cases, the so-called civil rights cases, and other cases that basically gut the 14th Amendment with regard to its serving as a basis for serious regime change with regard to race. Rick Pildes has written a marvelous piece on Giles versus Harris, in which the Supreme Court, perhaps understandably, says, look, if we're really to monitor voting suppression in Alabama, we would have to send the troops back in. The courts, in fact, do have limited resources, and we just can't meet this problem. Even Bailey versus Alabama, and this actually refers a bit to the earlier panel on the court's candor or lack of candor about race, whether it's in capital punishment, criminal punishment more generally, or other areas. Bailey versus Alabama, which does say that the convict leasing system in Alabama is unconstitutional, goes out of its way to maintain that it's not a case about race, that it might have arisen in New York or Idaho, and they'd come to the same conclusion, which is just batty in terms of the social reality of that case, but it does illustrate the difficulty that the court has always had in talking about the implications of the original sin. And one could also talk in this context of the maintenance, the rigorous maintenance, and for reasons that I still don't fully understand, it was Justice Brennan who insisted on maintaining the emphasis on intentional discrimination in Keyes, which is one of the cases that I was working with Tony on, rather than accepting Lewis Powell's deal, basically to accept disparate impact in return, of course, for getting rid of busing. So we ended up with the worst of worlds with regard to school segregation litigation. That is, you still have to prove intent. You still have to find the smoking gun instead of simply talk about the actual impact and the actual reality, so that in many places in the country today, segregation is just as serious a problem as it was at the time of Brown versus Board of Education. One could talk about Washington versus Davis or Jefferson versus Hackney, where again, the court emphasizes it's going to look for intent because it doesn't want to get into what would undoubtedly be a Pandora's box if one really and truly took disparate impact seriously and linked it with the original sin of slavery. In McCleskey versus Kemp, that the court couldn't have been clearer about it. Unless you accept the notion that death is different, So we're going to abolish capital punishment simply by saying death is so remarkably different. We're going to create a special law for it. But it'll be like Bush versus Gore. It won't have implications beyond the death penalty, because if McCleskey versus Kemp did have implications beyond the death penalty, then, as Lewis Powell was smart enough to recognize, it calls into question all of American criminal justice and all of the disparities that can be found throughout American criminal justice, in which, frankly and bluntly, in terms of a utilitarian analysis, capital punishment might be the least of it. It is the people in Ferguson and the people elsewhere who face jail sentences because they can't pay fines for driving without a license, or all of the people who are arrested for driving while black, courtesy of the United States Supreme Court, in a series of Fourth Amendment decisions, including a Fourth Amendment decision just this past year that I regret to say was joined by Justice Breyer, and frankly I don't understand why, that basically furthered the amount of power held by police and really refused to look at the context of American police civilian relations, particularly with regard to criminal justice. So this makes me quite obviously quite depressed with regard to thinking of constitutional litigation as a very promising area of reform in certain fundamental areas of American life, especially, and here I couldn't agree with Pam more, that in terms of distinguishing between the relative success, though it took 30 years, and the Supreme Court certainly never led the way. Rockefeller is basically mop-up operation more than it is a courageous exercise in leadership. But I think it is very clear that one of the things that helps to explain that is that even Lewis Powell, who famously or infamously told his gay clerk, his none-out gay clerk, that he had never met a gay person, Nobody can say that today. And there are human faces, not like the human faces who were shown to us earlier, that is, people who were caught up in the Texas criminal justice system, and we can certainly sympathize with them, maybe even empathize with them, but quite frankly, there is no practical likelihood that they're going to be part of our social circle. And that is not the case, obviously, with regard to the issues raised by Obergefell. But if one wants to talk about fundamental sorts of change in America, I think it is basically naive to look at courts as a source of much significant change. This is not to say that I'm hopeless, that I think marginal victories could be won, and I think that the abolition of the death penalty would be a very good thing. But what I do fear is that it could end up serving, as several people have already adverted to earlier today, as legitimizing a notion that this is a great leap forward for social justice, rather than treating a relatively small part of the American criminal justice system or the American society beyond that. And I do think the legitimation issue is extraordinarily important. And although I adored Bob Cover as much as I suspect most people or anybody in this room, I don't think his insight was completely original. Murray Edelman, a political scientist in the 1960s, wrote a wonderful book called The Symbolic Uses of Politics, the central thesis of which is that a lot of politics is position-taking, even legislation passing, designed to make the constituents, editorial writers, and the like feel good about progress being made. But if you are a professional politician, you know that the really important issue, especially in the age of the administrative state, which is the state we live in, is who staffs the agencies, who are the career civil servants, to what extent will they in fact enforce this splendid legislation, how much will the legislation be caught up in endless notice and comment and other ways of delaying rules forever. And then before Murray Edelman, there was actually Karl Marx in the German ideology, who suggested that one role of lawyers was to gild the lily and to offer an ideological justification of basically what the ruling class is doing. I've not used language like this for a number of years, but the events certainly of the last week, my wife and I marched for the first time, kind of inadvertently. We're in New York and found a march with regard to protesting the election. And it may be time to dust off some of the things we were reading and talking and arguing about 40 or 50 years ago in terms of discussing the way a legal system works in the language. I think it was Bernard Harcourt, though if it was, or Steve Bright, who talked about creating facades that will allow Supreme Court judges and others to give law day speeches on the splendors of the American legal system rather than talk about some of the very, very unhappy realities of the American legal system. I wish I could leave you happier at the end of the day.
We'll now hear from Mark Tushnet, a colleague of mine, and a birthday boy today. Oh, to be 71 again.
Excuse me. Thank you. So the topic for this panel is other capital litigation and other highly contested issues. And it's connected to the 7th chapter of the book, which Pam Carlin's already referred to, on recurring patterns. And I want to talk about recurring patterns in two divisions. The first is, I'm going to inaccurately label the popular level, and the second is the elite level. Now, when I say popular level, actually, that's a little, the misleadingness is that I actually have in mind two versions of accounts of the connection between a constitutional law and something associated with the people. One account connects constitutional law to political coalitions that are sustained over a sufficiently long period. This is an account that in political science probably originates, at least most famously associated with Robert Dahl, and it is an account that underlies the book by Robert McCluskey that Sandy continually updates. The notion here is that if a political coalition sustains itself in power over a sufficiently extended period, then you will be pretty sure to see that see constitutional law developing in a way consistent with the political and ideological interests of that coalition. And the mechanism here is pretty straightforward. The coalition's in power for long enough. It gets to make enough appointments to the Supreme Court and to the lower federal courts that its vision is able to, the coalition is able to implement its vision. And I should say it's reasonably clear that the gloom part of today's discussions is associated, at least in part, with that account of the connection between constitutional law and, call it broadly speaking, politics. We know that to-be President Trump will have one nomination to make to the Supreme Court. It may have more, and then the mechanism will kick in. Again, there's a footnote about whether the coalition will be in power for a long enough period to be able actually to implement, for the mechanism to have its effects. But I actually don't want to talk any more about that, because I want to talk about the other component, which is the connection between what are in the literature talked about as social movements and constitutional law. And here, there's a large body of scholarship over the past decades about things like the civil rights movement and its effect on constitutional law, women's rights movement and its effect on constitutional law, gay rights movement and its effect on constitutional law. And one point to make here is that although part of the story about how these movements affect constitutional law is connected to the appointment mechanism, that's only part of the story. Both with respect to women's rights and gay rights, it's really hard to tell the story as a story about how appointments were the mechanism by which the movement affected constitutional law. So what I want to raise here is the question about whether the anti-death penalty movement is part of the domain of the account of social movements and constitutional law. And there are a couple of reasons to think that it might be, but in the end, I think probably not. And that's where I want to go with this part of the discussion. One of the reasons that it might be part of the domain is if you look at what the topics are, civil rights and so on, it's the significance of the issue as a matter of social policy, again, over a reasonably sustained period. And it looks like the death penalty has that kind of significance. And then the other thing is, what I've already mentioned, sustained attention to the issue, and that's clearly true. One reason why attention can be sustained, and this is a connection to the notion of social movements, is that you need some sort of organization that will be able to support the sustained attention and litigation and the like over time. Now, these organizations in the, again, social movement literature would be associated with the social movements. Sandy's invoked Karl Marx, so I'll invoke the descendant. You might call these organic associations, using language from Antonio Gramsci. These are associations that are somehow just connected to a social movement and grow out of them. But I just want to note, we know from other developments that the organizations that sustain attention to an issue might not really be associated with something fairly described as a social movement. Here, the clearest example is the conservative activism that's been reasonably successful across a range of areas like limitations on access to justice and the transformation of the First Amendment in favor of corporate speech. There you do have organized actors behind it, but they're not connected to a mobilized public of the sort that's associated with the literature on social movements. Now, how does, yes, significant social issue, yes, sustained attention with some degree of organization behind it, but why not link the anti-death penalty movement to the literature on social movements in constitutional law? Well, I think primarily because supporters of abolition are organized, but they're not well described as a social movement. This is a very crude account suitable for this occasion, but not for any more sustained effort. Roughly speaking, social movements are composed in large measure of people who would be directly benefited by the success of the movement, although the word direct here is would need some unpacking. So the Black Lives Matter movement is a social movement in this sense. The people who participate in it, a large segment of the people who participate in it would benefit from successful transformation of policing and the like. That's not true of the anti-death penalty movement. The people who are active in it have a moral commitment, and they would be, in some sense, directly affected in that their I don't know what the right word would be, their connection, the connection they see between themselves and living in a morally acceptable society would be reinforced were they to succeed. But that's rather different from what you would think about the success of the Black Lives Matter movement. So in the end, although I think there is something to say about connecting the death penalty abolition movement to the literature on social movements and constitutional law, it's probably not a strong connection. But I now want to turn to the second part of my comments. There are also mechanisms of constitutional transformation that occur through elites. Here, the text for me is the work associated with Franklin Zimmering, and I think it's in a book with Gordon Hawkins, which makes the point by comparing, by examining death penalty abolition around the world. They argue that death penalty abolition around the world always occurs at the instance of an elite in situations where there is popular opposition or popular, at the very least, non-substantial popular support for death penalty. The death penalty nonetheless gets abolished at the instance of various elites. Sometimes they're legislative elites, not necessarily judicial elites, but elites are the ones in charge. So I want to talk a little bit about what the elite route to abolition might be. There's a first note here which is relevant to the outcomes of the referenda last week, which is because we're talking about elite-led decision-making, the referenda that uphold the death penalty or reinstituted, or however you want to characterize it, those are not relevant to this part of the discussion, except in a very indirect kind of way, which I'll mention, I may mention later on. So just focus on elite decision-making. Here, I think there are advocates of abolition have to think about two levels of persuasion. The first is a level of persuasion I call it on the policy merits. The second is a level of persuasion, or it is a persuasion about the constitutional merits. And a couple of subdivisions of the policy merits point that I'll make. But I want to assert, I don't have any survey evidence of the relevant sort to support this, just a sense of things. I just want to assert that on the elite level, the argument about the policy merits or demerits of the death penalty has basically prevailed. That is, elites in the country are not committed as a matter of, don't believe that as a matter of sound social policy, the nation ought to have the death penalty. I think that's probably right, but in any event, I want to assert it and say, then move on to that. For elites to act on that view of policy merits, there are a couple of additional things that are useful. One is that they have to think that acting on the belief that the death penalty is not good policy is politically defensible. And here, things like commutations, mass commutations, individual commutations, legislative abolition, that's relevant. It's not it's part of the checkbox, oh, the people are against the death penalty, but rather you can get away with it. Your political careers won't be ended by it. The innocence movement is also, I think, part of that, providing a political defense for elites who, in some sense, want to get away with it. The second thing is that the existence of constitutional questions also provides a defense. Not that the elites are saying, well, it is unconstitutional, it's just that there are lots of reasons to be nervous about it on the constitutional level. And it provides some cover. You might think of this as popular departmentalism, not in any formal way where governors say, I think the Constitution makes it unconstitutional, and so I'm going to do it, I'm going to commute death sentences. Okay, then the final point is the next level is elite persuasion about the constitutional merits of abolition. And here, what we've talked about already today is that the challenge on the constitutional challenge is coming from many directions. The innocence issue, the 5 counties study, the questions of delay. I do want to note that the humanization point is, for me, more ambiguous than it is humanization of capital defendants is more ambiguous. Mostly my only connection with death penalty cases indirectly through my wife, who at one point very near his execution had some collateral connection to Joe Giordano and met him and described him as a very scary person, and some subset of the people who are being executed are scary people. Some can't be humanized in the way, that the humanization account suggests. But the most important component, I think, is regulatory failure, which is the story, I think, the basic story of the book. Now, the elites say, okay, we don't like this on a policy level. Is it unconstitutional? We've tried to regulate it. Regulation has failed. What can we do now? Now, one response to regulatory failure is to deregulate. But that's not really available if you think that it's an unsound policy. So there's a line that I have adopted from Chuck Sable, which is, we have a problem, something has to be done, but nothing we've done worked. What's left is abolition, with a caveat that you have to work out abolition in a way that doesn't allow for replacement in the way that Gregg allowed for replacement. There are ways of doing that, I think. Although the accumulation of the various lines of attack in itself wouldn't do that. You'd have to add something more, like not an irrelevant term for what I'm going to say in a moment, something like a deep account of human dignity. And that's what I want to finish on. And this is about the prospect of what was referred to in the last panel as Furman II. And here, primary thing to note is the Supreme Court is if in my notes says a small N institution. There are just 9 people on it. They're individuals. Individuals, not theory, dominate in decision making. And what that means, and this is where I will end, is at the moment and for a while, a couple of years, the account will have to be about Anthony Kennedy. And there, I think what we know about Anthony Kennedy is that he is very attentive to his reputation among elites and and how he will be seen historically. If the arc of justice is long, the arc of history is long but bends towards justice, he knows where the historical endpoint will be, which is abolition. And so, just as he didn't want to be this is overstating him, he didn't want to be the person who said gay marriage is not constitutionally required when he knew that in 10 years it was going to be widespread around the country. So he might well think, I don't want to be the person who writes the opinion saying death penalty is absolutely fine. Last observation, this is the real inside baseball kind of observation, but I think that it's unlikely that Justice Breyer would have reopened the fundamental issue unless he had some sense that there was a serious prospect of getting Justice Kennedy's vote in the relatively near future. And again, I just want to note, if that's true, it doesn't matter who's appointed to fill Justice Scalia's seat. Okay, thank you.
Hi. I'd like to say a couple of words before opening it up to discussion. And I was thinking of talking about human dignity anyway. I think there is a pessimism in Sandy's work, he owns up to it, of course, that I don't quite share. When he says, for example, that courts are not likely to play an important role in reform, I remind him of the gay rights movement, in which, probably but for Goodridge, most people would continue to think, as Lewis Powell did, that they hadn't seen gay couples. The idea that the sky didn't fall when same-sex marriage was legitimated by the highest court of Massachusetts made a big difference. And I very much agree with Pam Karlan that as gay people came out of the closet, that generated a degree of empathy and of understanding. People understood that their brothers, their sisters, their close relatives, many of them were gay. I think that the appeal to the element of empathy and of human dignity, and I've written a lot about Justice Kennedy's centrality to that in the way that he sees liberty and equality not as values at war, but as part of a kind of double helix wound around an axis of dignity, helps explain a great deal. And I think there is an interesting tension in two of the things that Mark said. On the one hand, he said that judicial appointments probably are not likely to account for anything terribly important. And on the other hand, and I agree with him here, that it is the role of Anthony Kennedy and the anticipation by Steve Breyer that Tony Kennedy might in the end be a fifth vote that makes a lot of difference as to what will happen with death penalty jurisprudence. I don't agree, by the way, that it doesn't matter who is put on the court by Trump, because the notorious RBG is not the immortal Ruth Bader Ginsburg. So, and Trump is likely to be around for a while. It seems to me, just thinking of Kennedy for a moment, and thinking of the role of contingency, he made a huge difference to a very important concretization of a social movement into a political and cultural reality. Back in '86, when I testified against Robert Bork, I was certainly driven in part by his extremely transparent anti-gay attitude as expressed in a number of his opinions on the DC circuit. And I had friends who knew Anthony Kennedy, and who said that Kennedy would be, in the long run, very sympathetic to equality and dignity notwithstanding sexual orientation. So that when I argued Bowers and lost, I believed then that if the right person replaced Powell, it would only be a matter of a couple of decades before gay equality was the law of the land. So I testified for Kennedy, and the rest evolved. Kennedy clearly made a huge difference. That judicial appointment made a huge difference. Courts made a huge difference. Now, the history is very different with respect to the various topics we've talked about. And I think the reason, and I see this in what Pam said, has a lot to do with the ease of evoking empathy. I think that Mark is right that it's a lot harder to evoke empathy for what look to a lot of people like monstrous, cold-blooded killers than it is to evoke empathy either for women who are struggling with an unwanted pregnancy or for gay or trans people. It seems to me that the ease of evoking empathy and of therefore crossing political lines makes a huge difference. I also think even in abortion it made a big difference. Not only, and I'm now talking not only about empathy for the woman, but I think there is an important reality in that as science developed and sonograms made it easier for more and more people, including pregnant women, to visualize the unborn, it became harder to argue that this choice involves only one set of human values and human interests. In any case, I think empathy is the strand that runs through it all. And what I find most dismaying and distressing, going beyond the level of legal doctrine or possible judicial appointments, about what happened on November 8th, is my sense that it was a failure of empathy on both sides that put us in this crisis. A lot of people who think of themselves as liberals and progressives had a really hard time empathizing with rural America, with whites in places where manufacturing had been devastated, and therefore didn't appeal directly enough with policies or with rhetoric to that group. But what really scares me is the absolute absence of empathy on the part of those who support Trump. When he made fun of the disabled, when he dissed women, when he clearly expressed a kind of savage attitude toward other human beings, I fooled myself into thinking this is not a country in which someone who shows that little empathy could possibly be elected president. And I was obviously wrong, as were, I think, many of the people who assumed that it would transcend issues of policy, who would bring various ravaged economic areas back, that somehow we were too good a country to do what we did. And it's the dismaying lesson that that wasn't true that strikes me as kind of deeply troubling on the level of what any of us can do, politically or legally. But I want now to see if anyone has any comments about that, or if the people who are listening want to weigh in on what either Pam or Sandy or Mark said. Jordy?
I want to weigh in on the empathy, human dignity discussion. And the thing that I'm most persuaded about, and this is where I think I disagree with Pam, is that I really do believe that there's a way in which empathy and human dignity may be linked, but not in a way that human dignity will become central in the death penalty debate. It's true that I think there's a much greater likelihood of gaining support in the Supreme Court and in the world of public opinion if you can have an attractive face of the sort of social issue. I don't think that wrongfully convicted people sort of reflect an issue of human dignity, right? I don't think you have to have a very thin conception of human dignity to say that we shouldn't execute people who are actually innocent, right? The human dignity argument in the death penalty is that for people who are guilty, that there should be some empathy or concern that would justify sparing them from the ultimate punishment. And I think that that argument has virtually completely dropped out of public discourse, in part because of the way in which the Supreme Court framed the issue of the death penalty, partly because of the strategic choices that were made early on as well. And so I do think that when the death penalty is abolished, it's not because there is any powerful portrait of the condemned that people resonate with. It's going to be abolished because of things external to the condemned. And I think that it's sort of a sad, it's sort of a sad and poignant commentary on our Constitution and our discourse and our political and social history, that's how the death penalty is going to expire in the United States, when it's so different from the way in which other cultures conceive of the death penalty issue. So that's...
Let me just give a very brief response to that, which is, I think there's a distinction between what motivates and what the explanations are, the kind of reasons and the justifications. And I think without some level of empathy, it's very hard to care about the reasons that are then going to drive the court, which is, I think, it's not as if in the actual decisions in cases like Windsor or Obergefell, the court is talking about, I feel for these people because they're just like me. I mean, in a weird way, that never gets discussed by the court, right? But underlying it is, I can see some level of, and I can feel something. And I think that's why it turned out that I think there's such a difference in the discussion of innocence in the 2005 piece versus now. As you were very worried that what would happen is there'd be this huge wedge in which the innocence movement would lead people to say, well, as long as they're innocent, I'm with them, but otherwise the guilty don't have to worry about that. But it turned out that that isn't, and you make the point in the book, that isn't what happened, because it led people from a starting place that was an empathetic starting place into a broader understanding. And so I agree with you entirely. The Supreme Court is not going to write an opinion that is mostly about the dignity of man. But without some ability to get the justices to care about the people involved, it's very hard to get them to care about anything else. Which, I'll just say one thing that takes me back to Larry and Bowers against Hardwick, which is I was in the courtroom for Bowers, and then I was in the courtroom for Windsor and for Obergefell, and for Lawrence, for that matter. And I remember at the argument in Lawrence, after the argument, I was standing around with Walter Dellinger, and Linda Greenhouse came over, and Walter said, "What do you think that was the most interesting thing about the argument?" And Linda, without missing a beat, said, "The bar section of the Supreme Court." And what she meant by that was huge numbers of lesbian, gay, and bisexual clerks had come back. And when the justices came out from behind the bench, you could see Justice O'Connor going. And I said, "Yeah, Walter, when she got to you, the eyebrows went way up." And Walter said, no. But that move from nothing would be better for the death penalty than to have one of the justices' children wrongly accused of murder.
Or law clerks.
That's true, too.
I see a John Grisham novel developing here.
Yeah, in which Steve Bright frames a Supreme Court law clerk just to build that empathy.
Of course, the one problem in the death area is that a lot of people empathize so much with the victim that they don't see the human being on the other side. I mean, that grotesque dissent by Thomas talking about how, why should I empathize with somebody being stuck in a small cell for years awaiting his death when the victim is stuck in a smaller coffin having already been brutalized? I mean, that sort of empathy at least cuts both ways.
Yeah, absolutely.
I just want to say that you have to constantly disaggregate. Empathy in this area is alive and well in Black America. And so to talk about a lack of empathy, you have to also do a racial calculus.
Is opposition to the death penalty and the abolition movement stronger in Black America?
Is what?
Is there, in fact, empirical evidence that Black America is more anti-capital punishment?
Yeah.
Well, I'm sorry, I just didn't happen to know.
Yeah, the answer is
Okay.
One other quick thing. Then
Well,
I'll
of course, for the obvious reason that they know that black lives are not valued as much and that people who are black are more likely to be executed. Is that more empathy or is it more, yeah? That's part of it.
One other innocent space is that the justices now know that there are a series of people that they denied relief to in death penalty cases who have been since exonerated by DNA, and Justice Breyer mentions a couple of them
Right.
in Glossop, and so they have something to be haunted by, and that's new to them. So that's.
Well, and you guys make the point in the book about Justice Scalia using somebody who's later exonerated as the poster child for why we shouldn't care about procedural protections for people on death row.
How enviable a peaceful death as compared to this terrible crime of raping this girl, and it turns out the case that he's talking about, the defendants are later completely exonerated.
Yeah.
So that's
And I couldn't help thinking when people were discussing on the earlier panel, I'm sorry I didn't get into town in time, the Scottsboro boys thing that you all went to see, the fact that we have a president who has continued to argue that 5 innocent black and Latino teenagers should have been executed for a crime that we all now know, except for apparently our president-to-be, didn't commit the crime.
well, the prosecutors in that case too.
Yeah, well, but everybody else knows.
It does seem to me, though, that we need to return to a topic that came up earlier today, which is the Tsarnaev death sentence and Donald Verrilli's emphasis that whatever Eric Holder's opposition to the death penalty is, which I have to assume is sincere, it was irrelevant with regard to Tsarnaev. And so I think with the death penalty, unlike a very few, I hope only a very few fanatical opponents of non-heterosexuals, the retributive aspect. But retribution obviously is one of the central bases for all punishment, especially capital punishment. And so you get into the discussions of mass murderers or the commandant at Buchenwald or whatever, and what it would mean to treat them with dignity or to have empathy. Or do you simply say, well, if we had a perfect system of capital punishment, they would certainly deserve it. But since we don't, we're willing to pay the cost that they're not executed because you're afraid there will be mistakes otherwise. It also seems to me, apropos of the Obama administration, and I haven't worked this out carefully, but the debate over drone strikes, I think, is relevant to this. That is, the president has claimed the power, and let's assume it's statutory, not unilateral executive power, to execute without the semblance of due process, except that there are arguments with the executive branch, even American citizens. Now, the argument is forward-looking. It's utilitarian. It's not a retributive argument. But of course, if you believe in capital punishment, then there is the utilitarian argument that capital punishment will deter other people from doing this. I suspect that most people in this room don't accept that, either don't accept that argument because they don't think the data support it, or because we adopt one or another variety of deontological argument rooted in dignity or whatever. But it does seem to me that the issues raised by torture or by drone strikes have some family resemblance to the debate with regard to capital punishment, and generate the same, Wittgenstein once referred to intellectual cramps, because with regard to the torture, debate, the classic counter is always the ticking time bomb that will wipe away Chicago. And do you really oppose torture in that? That's in a certain sense of structural equivalent. Do you really oppose capital punishment in the case of fill in the blank? And I don't think the Supreme Court, some kind of their individually crafted cases, I don't think they've let any mass murderers go free.
I just want to say something. This is weirdly framed on behalf of Dzhokhar Tsarnaev. He got the death penalty because the police had killed his brother. His brother was this is a kid who was being led around by a brother who he had idolized for his whole life. They had difficult lives and so on. So, even, I want to say, now, whether the government properly brought the death charge against him is one thing. A jury, there's a case to be made for Tsarnaev in front of a jury, and it was made. I mean, he had very good representation. So I guess at some level that indicates the limitations of empathy under those kinds of circumstances. But, in my mind, he's not Joe Giordano. Now, I don't know Joe Giordano. Maybe something could have been said on his behalf. My wife called him scary.
Other questions from the audience or comments?
I had one.
Oh, I'm sorry. Yeah.
No. So I wanted to go back to Jordan's comment and the theme of the panel in terms of empathy of capital defendants more largely, and just say that I think that there is empathy, and it's all in the framing of it. So you may or may not have this actual innocence argument. Nobody wants to to execute someone who's innocent, but you've also got these. Well, you've got empathy in the sense of nobody who's on trial for their life should have a lawyer that falls asleep. And until we're ready to provide decent, minimally qualified capital defense to all of these people, we shouldn't have one. And we're not ready to do that. So, and I think, and even if you agree with the death penalty, nobody thinks, I don't think, except for maybe I should question that in the wake of the election, but nobody thinks that you should, get the death penalty depending upon the color of your skin or your economic status. So I feel like you're right, Mark, that there's certainly you're not going to get the same level of empathy that you have with other social movements, but I think there's still core issues endemic to the death penalty that allow for a lot of empathy for these folks, even the guilty ones.
Corinna, how much does that argument either depend on death is different, or do you want to confine it to death is different? Because Karen and I were talking about this earlier. I think first of all, I don't teach criminal law, so these are comments of a rank amateur. But for me, the most scandalous feature of the American criminal justice system is plea bargaining. And I'm one of those few people who read the second part of Sibelius as actually providing for a high doctrinal attack on plea bargaining as coercive that I do not, in fact, predict would be successful with the court, but I think it's a legitimate inference. But if you talked to people, if you explained to people how plea bargaining works, I would hope they would be scandalized. But, there's certainly no movement really to provide people even kind of the basic constitutional rights. I mean, again, a classic article in Political Science with regard to the criminal justice system is, and this is unfair to public defenders, but it's the public defender as kind of the agent of the prosecutor to encourage the clients to make deals. And there is certainly a reality to that, but are we prepared to get into that, or are the abolitionist arguments kind of carefully tailored to be limited to abolition of capital punishment.
I think it is a death is different argument. I mean, and I'd love to see, I mean, this goes back to McCleskey, I think. There was somebody saying, like, well, you know, they weren't going to bring down the whole criminal justice system, so they had to deny the claim. I think it would have been okay to say, at least when your life is at stake. You know, I'd like to see go a little rather than not go there at all. And I think death is different, although that's not to say I don't care about the atrocities that are everywhere else as well. But I think you can take a little without having to bring the whole house down.
This also goes back to the previous panel, and one of the things that I had been thinking about when thinking about what the panel on criminal justice more generally was going to talk about is there were some very unlikely coalitions on the Supreme Court on other criminal justice issues. So the most obvious one, of course, was the Confrontation Clause, where it was the ends against the middle. But I think you also saw this, like in the Yates case, you know, the fish throwback case. Justice Kagan has a really interesting dissent there that says, look, the real problem here, and let's be candid about this, is the massive over-criminalization.
Right.
That is, plea bargaining would be very different if the discounts weren't so savagely coercive. That is, if you faced 2 years rather than 1 year, it wouldn't be the same as, well, it's life or, you know, probation, at which point, of course, everybody's going to plead guilty whether they have a good defense or not. And I wonder whether that's an issue that we may see coming up again and again.
You know, back
to that, the penalty for going to trial.
Well, that's what. That's part of
Right.
what I mean.
Well, you know, the court in the late 60s in the Jackson case said that even if the person is making an intelligent, uncoerced decision, you have to have a compelling justification for creating incentives to waive your right to go to trial and to waive your right to a jury. And the combination of Jackson and Brady was you don't have to prove coercion, and in fact, a guilty plea could be non-coerced, and yet the system of which it was a part might be unconstitutional. And I think,
Not followed.
Jackson has not been followed?
That principle.
No, yes, it has been. I beg to differ. I think that even the Roberts opinion in Agency for International Development said that a condition can be unconstitutional without being coercive. It hasn't been followed in the criminal justice field, but there is a strand of jurisprudence that I think will, in the long run, and by the long run I mean long after I'm here, support a re-examination of what Kennedy began when he said, plea bargaining is an alternative system of justice, and we at least have to assure good legal representation in plea bargaining. Now, given that the court's standard for adequate representation is so pathetically low, that is only just a seed that has to grow into something. But I think it's an important seed. Should we wind it up, Carol?
Maybe we should. I'm going to just close us this evening. I just want to thank all of the panelists throughout the day for their extraordinary contributions, and especially Mark Tushnet for contributing on his birthday. I didn't know that, or I would have exempted you. I want to invite everyone who's here. There will be a drinks and hors d'oeuvre reception just in 2 doors down, and the equivalent of this room that's labeled A. We're in C, so just walk down to A. There will be drinks and hors d'oeuvres, and Jordan and I will be happy to sign books for anyone who'd like to do that. So thank you all, and we hope to see you down the hall.